Ssentebe w'akakiiko k'eby'ettaka mu Kampala aka Kampala District Land Board, Ebya Balondemu ne bannaabala babiri bwe bawennemba n'emisango egyekuusa okukubba $5,000 okuva ku kampuni ya KG Limited LCC mu lukujjukujju nate balabiseeko mu kkooti ya Buganda Road mu Kampala okugenda mu maaso n'emisango egibavunaanibwa. Wabula omuvunaanamukulu Eric Geoffrey ono nga kkooti emu ekibalaba kye bakuntumye yeeyanjulidde kkooti n'asomerwa emisango gye gimu wabula agyegaanya.
Balondemu David and Ivona Joseph. All charged with 2 counts. The first count, statement of offense, is obtaining money by false pretense, contraception used of by for the penalty count. Balondemu David, Eric Geoffrey, Ivona Joseph, and others still at large between the month of November 2022 and April of 2023 at Bloom and Projects located at Kingdom Kampala in the Kampala district with intent to fraud obtained United States dollars $553,000 from KE Unlimited LLC by cost representing that we are going to award it a contract of supplying agricultural drones, sprayers and fertilizers from Ministry of Agriculture, Animal Industry and Fisheries, whereas not.
You understood the judge? You understood the offense? Is it true?
It is still alleged that West Ronald Kizito, alias Munisime names, Balondemu David, Eric Onifre, Ivona Joseph, and others still at large between the month of November the year 2022 and April of this year at Bloom Advocate located at Kingdom Kampala in the Kampala district. Conspired together committed felony with obtaining money by false pretense under section 305 of the Penal Code Act worth $553,000 from KK Unlimited LLC.
Mu maaso g'omulamuzi Jatiko Winnie Nancha, kkooti ebadde yakuwa ensala mu kusaba kwa Balondemu ne munne Joseph Ibona okw'okuteeba ku kakalu, wabula kino tekisobose oluvannyuma lw'oludda oluwabye okusaba mu kkooti nga lubakanya ensala eno okugenda mu maaso. Mu kusaba kuno oludda olwabye lutegeezezza nti Balondemu yakozesa ebipapula by'eddwaliro ebijingirire ng'asaba kkooti okweyimirira era byolese mu bujulizi obwakoleddwa omusirikale okwa Col Joram.
This matter is coming up today for ruling in the application for both A2, Mr. Balondemu David, and A4, Mr. Antonio. Following their applications that they have made order on their behalf. We have, however, Your Worship, filed a criminal business application today, which relates to the information that was submitted by A2 in support of his bail application, which we feel that this court needs to address its mind before delivering the ruling in that application. We ask Your Worship seeking of court to allow us execution basis the already filed business application, which is MA 53/2023. Your Worship, the application has a bearing on today's bail application ruling. Because some of the documents that were submitted to this court by A2, particularly the medical documents which indicate that A2 was scheduled for assembly today. Your Worship, we have attached a copy of the letter from Kampala Hospital.
So are you seeking leave of court to go into the
To
merits
defer
of
the ruling,
this?
Your Worship, say
To
that
defer.
yes, to defer today's ruling for pending the hearing of the business application, which we have filed to the Worship. The application which we filed indicates that the medical documents that form the basis of the application for people, and the very reason why the case was deferred today for a ruling was because A2 intimated to court that it was scheduled for assembly today, carrying out the verification exercise to confirm that those documents were forged. So we pray that the court allows us to add to that application before it delivers the ruling of the application.
Obw'obula bannamateeka ababavunaana babakanyiza okusaba kuno bwe bategeeza nti kkooti erina obuyinza okuwa ensala yayo mu nsonga eno nga terina kutaataaganyizibwa kwonna.
Was categorically held Fangam versus that of the constitutional court. There can never be a trial by ambush. Even asking us or asking you to defer the matter for reasons which are not known to the defense is itself slap your eyes, Article 28 of the Constitution of the Republic. Secondly, Your Honor, your granting of bail, unless under the Trial of Indictments Act, does not require an exceptional circumstances. With or without medical documents, once court is assured that the accused person will attend his trial and that it can put up measures for him to remain within the jurisdiction or to move there out with the permission of the court, it can grant bail. This court does not grant bail under Section 15 of the bikyaali, in which exceptional circumstances are required, such as the application filed, Your Honor and Worship, is novel. It's novel in that it has never been filed, and it paints the state in bad light as doing everything possible to curtail the grant of bail. Only A2. They added the A2 to the charge even after A1 confessed is the one who took the money, picked the money from the law firm, but they are following the deep pocket theory, thinking that because the A2 works with the land board, maybe it can coffin. That is in the reality of the dream. We therefore pray on that there are no reasons for arresting a ruling. Reasons for arresting a decision were stated in Dr. Isaac Newton versus Uganda Supreme Court Criminal Appeal number 31 of 1991. They can only relate to the biasness of the magistrate, or that the ruling no longer has relevance. Applications to bring additional evidence can be made orally and do not require filing an application and applying to the fair ruling. We therefore pray that you be pleased to deliver the ruling if the state, and they still have a chance, feel that the bail was granted on erroneous grounds, they can still apply for. They don't know your ruling. You might even reject the bail application. So in the case they are dissatisfied with the ruling, they can appeal and bring additional evidence at that stage. It's presented before you yesterday at length to take us back to point A, when the court is going to deliver the ruling. We seriously pray, Your Honor, that the intention of the application is now known to the whole world. They are witch hunting A2. Because A4 did not bring any documentary, any medical documents. And you see they are not saying anything about it. So why would the court even defer the entire ruling on bail? It is a classical, to use the words of my brother, classical horror scheme.
In addition, Your Honor, this court has a very clear law under which it operates, particularly Section 77 thereof. Prosecution was given ample time under the right of liberty. That was the time, Your Honor, when such a reply would carry any intended application that prosecution is alluding to. In the premises, Your Honor, they ought to have sought an adjournment for purposes of concluding their prosecutorial business before this honorable court, Your Honor, for reply. Your Honor, still, the Constitution, in brackets, bail guidelines for courts of judicature, in brackets, practice, directions 2022, have given credence guiding courts on bail decision making in compliance with the constitutional provisions. And that is under guideline 3A, Your Honor. Guideline 13.1, Your Honor, is very express that exceptional circumstances are no longer mandatory. And Your Honor, even the safety of the complainant is guaranteed since he was alluded to be outside the country. Finally, Your Honor, bail, there is a lot of jurisprudence on bail. In the Black's Law Dictionary, 10th edition, Your Honor, at page 167, bail is defined as a process by which a person is released from custody on majorly two grounds, either on the undertaking of the sureties or his own recognizance for future appearance when needed. Your Honor, to that extent, prosecution trying to delay a ruling on an application for bail, on speculative applications and even results of such applications, is unjustifiable, unconstitutional, and with due regard, my learned colleague is seemingly hell-bent and pertinacious on holding, particularly A2 in custody.
The so-called application that he intends to bring before this court has issues of forgery. You know, forgery is such a serious allegation that it cannot be proved by affidavit or mere application. If there was forgery, Your Honor, the same has to be reported to the police, and the due process has to be undertaken. the culprits must be brought who authored those documents. Your Honor, we don't know who exactly authored the documents that our land colleague wants to rely on, as he states. We have not been given an opportunity to look at those particular documents he's talking about. Your Honor, secondly, this is a matter that involves the State House Anti-Corruption Unit. They have a coercive nature towards certain individuals. We are yet to suspect that there was a coercive approach to this
I
matter.
want to stop you right there.
Most of like Your Honor, I want to add that this application is grounded under the Magistrates Court Act. It is not an application. The court is at liberty even to ignore and sever issues of medical grounds without wasting time. So it's an exercise in futility for our land colleague to arrest judgment at this time when the court is out deliberating. Your Honor, we invite this court to deliver the ruling in respect of the bail application.
We dissociate ourselves from the submissions made by the Land Affairs Council relating to application seeking leave and to defer the ruling of the application. Your Worship, is not a coincidence that today, 22nd of November 2023, out of the 8 advocates who appeared on the 20th of November, they are all
In this court, unfortunately, our land colleague was playing ping pong with his application. Mr. Alaka is appearing in the Supreme Court, and as well as Mr. Ocheng. He had to leave because he had a matter in the Supreme Court.
Allow him make his submission.
But we should restrict the rejoinder at what we say instead of
Why is it going back?
And so do not worry. When he swears so, I'll put him through.
Most of likely.
If I have
Worship, we wish to bring to the attention of the court that the well-known case of Makula International Limited versus his enemies Kanye Isu. The court held that where an illegality or fraud has been brought to the attention of the court, the court cannot overlook and close its eyes. What we did this morning, Worship, we have brought to the attention of this court the fraud which happened in the course of the oil bill applications that were made by the Land Affairs Council of his persons. The bail guidelines referred to by the defense do not in any way allow. Your Worship, this court on 20th of November this year was standing to a crime scene when the question documents have been found to be full and the scene has been brought to the attention of this court. This court to be pleased to defer. There is been application pending the disposal.
Banira bongeddeko nti obujulizi bw'omusirikale Okakoolo tebuliimu nsa ne basaba kkooti ebugobe.
As we were here during the morning, we thought that the doctor is the one who had performed an affidavit to prove documents from purportedly from Kampala Hospital. That was because we had not been served with the application which we received a few minutes ago. We have since established, Your Honor, that this application is supported by an incompetent affidavit of number 57574 DC of Pakol Joram. Incompetent upon matters which he deposed to the essence of this affidavit is to introduce the obtaining of a letter from Kampala Hospital from Dr. Peter Chibuka from CEO's office. This is the CEO, Kampala Hospital, which is annexed E. First of all, Your Honor, the letter annexed D to the affidavit in support of application requesting for the clarification from the executive officer Kampala Hospital was not written. It was written by Mara Fred for Deputy Director CID Economic Fraud and Anti-Corruption. In the affidavit in support of application, the opening introduction from I number is, it clearly shows that Pakol Joram is attached to CPS Kampala and is not attached to the Directorate of Economic Fraud and Corruption, from where the letter Kampala Hospital purported originated from. The letter was not even copied to CPS. Nor is it the same, nor did Mr. Pakol obtain a certified copy, since this is a public document, nor has he explained how he became associated with this hospital. First of all, the letters, as you can see, Your Honor, first of all, annexed D, the letter from CID, from the Director CID Economic Fraud and Corruption, does not attach any letters which the police was asking the Kampala Hospital to investigate. Even Annexed E was not addressed to the mighty Okwakol. I was going to say Rick Okwakol, let me use mighty Yom. To the mighty Okwakol, but it is addressed to the Director, Criminal Investigations Director, CID. This makes, Your Honor, this affidavit full of hearsay, as the witness was not the author of the documents. They are not copied to him. He didn't say he was there while they were being written. It is therefore a hearsay affidavit. The requests by the CID headquarters, Economic Fraud and Corruption, they never touched 10 of the letters they were inquiring about, which renders even an extra in the letter from Kampala Hospital suspect. Because without first looking at the letters and medical documents which were in evidence, it means this man was either compelled to write this letter or he wrote it to help the state deny to pay. No request on record to request for the documents we tendered for them to be taken, and those were the only copies we had. This smells, Your Honor, a very fraudulent application, which we pray that you exercise your discretion.
An incurable defective affidavit has to be struck out. And once it is struck out, then the application collapses. Your Worship, my learned friend, Hassan Kamba, has pointed out instances which indicate that the deponent in this affidavit, the deponent of this affidavit in support of the application, is not privy to the information which renders his affidavit in support of the application incompetent. Your Worship, in the case of Uganda versus Bogere, Bamuli, High Court Criminal Session case number 0437 of 2010, Uganda versus Bogere, Bamuli. High Court Criminal Session case number 0437 of 2010, the Honorable Lady Justice Percy Naitu Haise, as she then was, stated that hearsay evidence is evidence which the witness is merely reporting. That hearsay evidence is evidence which the witness is merely reporting, and not what he himself, or herself saw or had or came under the immediate observation of his or her bodily senses. But what he or she learned respectively through the medium of a third person. As a result, court restated the law that hearsay evidence is inadmissible. Police officer is not the author of the letter attached as an extra D. Address to the Chief Executive Officer of the said hospital. Neither is this letter copied to him. So he's not privy to this letter. It was not addressed to him. He's not the author, and it was not copied to him. 2, there's an extra E, which is a response to request for information. The author of that letter did not copy that letter to the deponent of this affidavit and did not address it to the deponent. And these are private documents. These are not public documents. These are not public documents. These are private documents. So he cannot depone as a third party to prove or to demonstrate these private documents. There's no linkage between him and these documents. So to that extent, anything he says on these documents is hearsay evidence.
Mr. Okwakol, in his paragraph 1 of the affidavit, vividly states,
Whoever has their phone, kindly turn it off.
vividly states that he is a police officer attached to seek his kafala. He does not show his relationship between the documents he's attaching on this affidavit, whether as an employee of Kampala Hospital or a records officer of Kampala Hospital or Chibuli CID reporters. In that respect, to have obtained these annexures or documents that are attached to this affidavit. Your Honor, this affidavit is hollow. It has no evidential value. It is full of falsehoods. And it should be struck off. People who got instructions. Then why is it that Mr. Lumala now is the one who is requesting for documents to verify? He even says in paragraph 11, to make matters worse, that I submitted the request for information together with the copies of the questioned documents. The letter by Mr. Lumala is very instructive. It does not contain those documents that they were questioning. And Mr. Papoli is not privy to the document authored by Mr. Lumala. Even the response from Kampala Hospital is not anywhere, it's alien. He just fell from the sky and came to this court and said, I am the one who perceived all this information. That is a total falsehood. Your Honor, on the issue of the application, it is claimed that this application seeks to find that the tendering of false medical documents is contempt of court. Your Honor, first and foremost, an application for contempt of court is a special application that requires a full trial with the evidence on how a certain party is contemnous. It is not wishful thinking of the state. Your Honor, it is our humble submission that this application, first and foremost, Your Honor, first and foremost, I've forgotten. It is first and foremost grounded like a bail application under Article 23, 6A and 28 of the Constitution. First and foremost, Your Honor, the application for bail was disposed of by this honorable court. and the court retired to issue its ruling. In fact, Mr. Chaze has now become the applicant of our bail application. And indeed, his application is not grounded anywhere in the law, as he seeks. Lastly, Your Honor, this application is only hinged against the A2, although it is stated Uganda versus Balondemu David and Ebya Joseph. There is no averment whatsoever in respect of A4, Ebya Joseph. And this is the continuous witch hunt that we have been stating in this honorable court. That the state is out in full gear to which hunt A2.
Wano omulamuzi Winnie Nanchi oluvannyuma lw'okuwuliriza enjuyi zonna alagidde oludda oluwabya okuteekayo okwewozaako kwalwo mu buwandiike olwawa ensala ye mu nsonga eno ng'ennaku z'omwezi 29 omwezi guno.
So to the fact that this application eminently came to be filed in this court as a premise or based on a bail application that was earlier made and documents submitted. The court feels that to make a determination at this point without the state being heard will be delivering justice on a one-sided note. The state also deserves the right of reply on the same. What I will do is give a very short adjournment to allow the prosecution defend whatever objections have been made in the application. Then we can reconvene and a final decision made on both the bail application and this particular application. And team the earliest convenient date. I don't want to drag it too far.
It's tomorrow.
Because I know it's a matter of liberty.
Why is that? You know, why, when I say the earliest convenient date is tomorrow, why is that state check?
I was saying for the court, not for you.
Okay.
The most earliest convenient date.
Kigambibwa nti David Balondemu, mukwe Eric Geoffrey, Joseph Ibona n'abalala abakyanoonyezebwa babadde oleesebwa $50,000 mu lukujjukujju okuva ku kampuni ya KG Limited LCC wakati w'omwezi gwa 11 omwaka oguwedde n'omwezi ogw'okuna omwaka guno. Bano bazziddwayo kwa limanda eluzira okutuusa ng'ennaku z'omwezi 29 omwezi guno. Mu ngeri y'emu, kkooti y'ensi yonna ewozesa emisango gy'abakalintalo etaddewo olwanga 25 omwezi ogwa January omwaka ogujja okugenda mu maaso n'okuwuliriza omusango oguvunaanibwa Jamal Kiyimba agambibwa okubeera w'akabinja k'abatujja ka ADF. Kino kiddiridde abajulizi mu musango guno obutalabikako mu kkooti, bw'atyo omulamuzi Susan Okalanyi n'agwongezaayo. Jamil Kiyimba avunaanibwa emisango egy'okubeera mu kabinja k'abatujja ka ADF ssaako n'okukkiriza nti akakolera ekigambibwa nti yagiddiza mu ggwanga lya DRC ssaako ne Uganda.